Well, welcome back, and we today are covering point number 8 from the AAHOA 12 Points of Fair Franchising. And before we jump in, I should encourage you that if you have not yet had an opportunity to review points 1 through 7 of this video series, I would encourage you to go and find them on the AAHOA website and to watch them carefully, because they are designed as an educational tool to make it easier for you to better understand the terms of your franchise agreement and also to work with your franchisors to ensure communications are open and you understand the relationship and the policies and practices of your franchisor. So let's immediately jump then into point number 8, and this is dispute resolution. And this has to do with if a legal dispute arises between you and your franchisor, what is the process? Most franchise agreements across the industry provide that it goes to binding arbitration. And what that means is that there is an arbitration proceeding that is set up usually in the city and the state of the franchisor, not where your hotel is located. And that means you would then have to travel to the state where your franchisor is located, go to a legal proceeding, present evidence before an arbitrator or a panel of arbitrator, and they then make the decision on whatever the dispute is, and it's binding, meaning there's no rights of appeal. You cannot take it to a court. You do not have any other options once that binding decision is made. So AAHOA, in the interest of fairness, has come up with point number 8, which provides that in all franchise agreements, franchisors and franchisees should commit to establishing an independent and fair process for the resolution of any dispute concerning the terms of a franchise agreement itself or the relationships between the parties. So let's talk about the specifics. That the franchisor and the franchisees should agree in good faith to participate in an informal, in-person meeting between the authorized representatives of the parties to resolve a dispute. And so that means before anything goes to a legal binding arbitration, the heads, the representatives of the key parties should get together with an informal meeting to address the issues and see if it can be resolved. If the informal meeting is unsuccessful, the parties should then agree to participate in a non-binding mediation before a mediator who is neutral and mutually acceptable to the parties. That means that then you can go in front of somebody who is neutral, who does not have a stake in what the result is, and they can help to mediate this dispute, to bring the parties together to discuss it and determine a fair resolution. Now, if the mediation is then unsuccessful, the dispute should not be automatically submitted to binding arbitration unless and until all the parties agree to do so. You should not be forced to just go to binding arbitration. Instead, they should determine who would hear the dispute, the location of the arbitration proceeding, and the rules and procedures for the arbitration. And before all the parties agree to arbitration, franchisors must also provide to the franchisees written information that clearly advises the franchisee that it is then relinquishing its right to a jury trial, because that is also very important for you to know that if it goes to binding arbitration, as we discussed, that means it does not go to a court of law and there is no jury trial available. Absent an agreement by the franchisor and franchisee to use binding arbitration to resolve their dispute, any party should also be allowed to pursue its claims in a court of law. And that should be clearly set forth so that everybody has the same rights to move forward. Let's turn now to the questionnaire that we had discussed at the beginning of this session that you can download from the AAHOA website. And let me give you some examples of the questions that you could ask your franchisor either before you sign your franchise agreement or if a dispute were to arise. Number one, do you commit to establishing an independent and fair process for the resolution of any disputes concerning the terms of the franchise agreement itself or the relationship between the parties? Very important question. Find that out up front. The third question, do you agree not to submit a dispute to binding arbitration unless and until the parties mutually agree to do so, including mutually agreeing to the arbitrator, the location of the arbitration, and the corresponding rules and procedures for the arbitration? And then the fourth question, absent an agreement by you, the franchisor, and a franchisee to use binding arbitration to resolve a dispute, do you agree that any party should be entitled to pursue its claims against the other party in a court of law with the waiver of the right to a jury trial and no caps or limits on the amounts of damages, including punitive damages? These are key elements of this point to ensure that there is fairness in the dispute resolution process. And in fact, I will share with you some good news that as part of these recent negotiations with the various franchisors, one franchisor in particular is taking a close look at this and looking at establishing a new dispute resolution process before the parties would be headed to binding arbitration. So let's now turn and hear from another leader in the industry on this particular point who can give some additional input on why this is so important.
Dispute resolutions occurs obviously when there's been a failure in the system between one party and the other. However, going forward, the way that can be resolved is with a third-party mediation and or between yourselves. Let's address it between yourselves. When a third person is involved, why does it have to be at the discretion of the franchise? Why is it not an agreed mediator? Why is it not held in a neutral place? Either have it halfway or in the state that the property is registered. So let's have all good intent to continue the relationship going forward.
I think the key thing is to remind the franchisor and remind yourself that we have a financial situation. We have a financial issue. It's not a legal issue. We don't immediately have to go to grab an attorney, because quite often I feel it's like quick draw on the and what happens is I hire an attorney, they hire an attorney, and we're not resolving what is the basic issue. And the basic issue for the sanity of yourself and your family and the business operation and for the franchisor, I think it's best to come across this with open eyes but open ears.
That small initial investment of getting somebody to read that contract on your behalf will hold you well in the long run. When there is a dispute, you'll be better educated, and because you've negotiated the terms. You can do that with legal advice and knowing that AAHOA has your back with these new 12 points.
There's a lot of things in play. I think the best thing for our industry, for our membership, is to understand where we're coming from. I don't think we want to be in a litigious industry. So let's try to find a way to move the ball forward and level the playing field so it's good for both sides. And I'll tell you this, the brands, there's a couple of brands that have been really good at speaking to our home membership and perhaps you can call it letting things go, being willing to forgive some and promise other things for the future. But that has been the winning formula for why people return to that brand over and over and over again.
And with AAHOA's help and understanding, members can be better informed by educating themselves to get to the 12 points and get AAHOA's assistance. It's there in black and white already to negotiate the FDD when you receive it and to negotiate the franchise agreement with your franchise.
And this goes back to the 12 points. What is your relationship like with the franchisor? If you're not keeping up with that relationship, that's when these things can suffer. There's always a way to resolve this. I'm reminded of a Lincoln quote, the last recourse should be going to an attorney to help you resolve your dispute, whether it be in business, whether it be in family or anywhere else.
So thank you again for joining us for this important point number 8 of AAHOA's 12 Points of Fair Franchising. And we look forward to seeing you next time for point number 9 as we continue in this battle for victory after victory in the process for establishing fair franchising. Thank you.